My name's Dan Cheater. I'm a lawyer with Ecojustice in Vancouver, and I'm going to be talking today about a project that we're doing on behalf of a few different groups to try to get 6-PPD regulated federally under the Canadian Environmental Protection Act. And does this work? Maybe not. Oh, I'll try it. If you haven't heard of Ecojustice, we're Canada's largest environmental law charity, primarily lawyers. We also have a few scientists on staff. And what we do is we provide free legal services to the environmental community to raise matters of environmental importance. There's a bunch of different projects we do, but it includes litigation on behalf of groups in court, also just general advocacy, trying to get government to take action to protect the environment, also law reform, strengthening our environmental laws, and then some educational pieces as well. To give you an overview of what I'm going to be talking about today, I'll start by just giving the main bullet points of what we're asking the federal government to do under the Canadian Environmental Protection Act. And I'll say at the outset, normally when I do presentations, I tend to talk more about the environmental issues, but given how we've heard about it all day and this group's super informed and engaged, that means I'm going to be focusing instead on the law. And hopefully that's not too boring. I'll have fewer pictures of fish and more talking about the Constitution. So I hope that sounds exciting. But I'm going to be talking about why we've chosen this first step to pursue under the Canadian Environmental Protection Act due to regulation that we've seen of 6-PPD in other jurisdictions, or at least the first step towards regulation. I'm also going to be talking about some of the challenges that we have in Canada in regulating toxics generally, and honestly just generally getting laws that protect the environment in Canada. I'll be talking about the process under the Canadian Environmental Protection Act and why we're trying to kickstart it with our request and get the steps moving towards regulating 6-PPD. And I'll wrap up by talking about what we expect to see happen next. So to start with our actual request, we submitted this in February of this year on behalf of three groups, Pacific Salmon Foundation, Raincoast Conservation Foundation, and the Watershed Watch Salmon Society. And it was based on all of the evidence that you've been hearing about today, evidence of toxicity, how widespread 6-PPD is globally and in Canada. The basis for our request is it's under Section 76 of the Canadian Environmental Protection Act. This is a section that allows anyone to write to the minister, that being Minister of Environment and Climate Change, Minister Guilbeault, to assess a substance and determine whether it's toxic or capable of becoming toxic. And I think that second point is important here. I know Ed was speaking earlier about how 6-PPD is itself toxic, but because so much of the evidence is about 6-PPD quinone, it's important that it's not just substances that are toxic, it's what they turn into and those effects after that. And in essence, what we're asking the federal government to do is prioritize assessing 6-PPD, hopefully finding it to be toxic based on all of this evidence. And once it's listed as toxic, that means the federal government can regulate 6-PPD, potentially prohibit it, force manufacturers to find alternatives, et cetera. But that first step is getting it found as toxic and listing it under the Canadian Environmental Protection Act. So that's super important. We were inspired in part by action we've seen elsewhere. So two of our US neighbor states have already taken steps to start regulating 6-PPD. State of Washington has tasked its Department of Ecology with assessing alternatives to 6-PPD. In California, they've also added 6-PPD to their priority product list, and they're requiring manufacturers to evaluate alternatives and take steps to reduce use. And the US Environmental Protection Agency has granted a petition that's quite similar to what we're asking the federal government to do. So it's kickstarting the process under their federal toxic substances law to inform future regulatory action and take steps to mitigate the risks of 6-PPD. We've also seen activity in Europe to start regulating, not specifically 6-PPD, but this broader issue of non-tailpipe emissions. This is the 7th iteration of vehicle regulations out of Europe. That's why it's Euro 7. And what it does is it sets abrasion rate limits for tires and for brakes. So grams per 1,000 kilometers. And it's currently awaiting formal approval, but it's expected to start applying as early as 2030. And really, globally, to this point, it's only been tailpipe exhaust that's been scrutinized by regulators. So we're starting to see at least Europe take steps to address the problem of tires and brakes, not just 6-PBD, but all the particulate matter coming off. And Canada's falling behind, which is pretty common. We tend to be a follower rather than a leader. But luckily, because we're seeing these jurisdictions take steps, that really helps us with our request. So if you've never heard of the Canadian Environmental Protection Act, it's our primary federal law for pollution prevention, for regulating toxic substances, and for protecting human health and the environment. And we're trying to use the Canadian Environmental Protection Act because it provides an opportunity to address this problem at a national scale. Like I said, it allows, once a substance is found toxic, it allows for regulation, for prohibition, or even virtual elimination, although in practice, that's only happened a couple times. Essentially, that means it can't even be detected in Canada, and there's been a lot of debate about how difficult that is. So our goal would be more about prohibiting manufacture and import, not necessarily virtual elimination. But there's a couple threshold issues with getting something regulated. The first is that for Canada to regulate 6-PBD, it first has to be proven toxic. So there has to be some connection between harm and the substance that is seeking to be regulated. They can't just regulate any chemical. And I'll explain why in a second. It goes back to our Constitution. Exciting stuff. The other big problem, and some of you may be familiar with this, is that the assessment process can be super long, drawn out, delayed for years, and ineffective. And there's a lot of discretion built into the Act that allows for delay. And again, one of our goals with our current request is to kickstart that process and get it listed as toxic as soon as possible. So that big problem I'm talking about, it stems from our Constitution. This reason why the federal government needs to prove harm and toxicity. It's because there's no clear jurisdiction for the federal government to regulate toxics. And honestly, there's not really clear jurisdiction for the provinces or municipalities either. Our Constitution dates back to the 1800s. And for those that don't know, there's a list of areas that the federal government can regulate. There's also a list of areas that the province can regulate. This dates back to 1867. And there was no conception of environmental protection back then. There was barely a conception of the environment, at least not in the way that we think about it today. And so it's super unclear how either level of government can enact laws that protect the environment. And it's been left to the Canadian courts to explain who can do what and how. The federal government does have at least jurisdiction over fisheries, which is helpful for this specific request. It's fish that are being most significantly impacted. But other than that, it's not great. These are like the best examples I could draw from the Constitution of like vaguely environmental things. And they're not very environmental. Like navigation and shipping, kind of connected to the ocean environment, international and interprovincial matters that pertains to railways and pipelines and things that cross borders. But apart from that, you don't see toxic substances in the Constitution. The province's situation is a little bit better. They have control over local works and undertakings, natural resources, although that's much more about extracting resources than it is about protecting them. Also property and civil rights and public lands. So there's a little bit more discretion for the provincial government to regulate things within their borders. But the federal government doesn't appear to have much. The one at the bottom is actually the most significant for the federal government. It's the criminal law power. And I think I skipped over. Oh, I just want to point out one other problem that stems from this not being in the Constitution. Essentially, it creates two problems. One is that neither level of government has to do anything to protect the environment. And then if action is taken by an ambitious government, they very often face legal challenges. So whether it's the provinces or industry, someone will say what they're doing is unconstitutional. And that's the case for the Canadian Environmental Protection Act. It's the case for a lot of things. I can give a couple examples of that. You might remember back in 2019, 2020, the BC government tried to regulate heavy oil that was coming in through the Trans Mountain pipeline. And the court said, no, you can't regulate that as a hazardous substance. You're trying to take away federal jurisdiction over pipelines, and that's not permitted. Similarly, the federal government is continuing to try to ban single-use plastics, actually under SEPA, and they've also been facing a lot of legal challenges from the provinces who are saying you can't just regulate anything. It has to be toxic. You really have to prove the harm. Of course, there is harm coming from single-use plastics. It's still in the courts, but my point is when you take ambitious steps, you face legal action, and that creates a disincentive for governments to act. So going back to this point about the criminal law power and why that's so important for regulating toxic substances. In 1997, the Supreme Court of Canada issued a very important decision on the Canadian government, on the federal government's ability to protect the environment and specifically toxic substances. The court found that it was valid for the federal government to regulate toxics under the criminal law power. And as part of this, the court recognized that the Constitution needs to be a living document. It needs to evolve over time and adjust to emerging realities, one of those being that we now realize that substances are toxic and harmful, and government needs to be able to take action. And so the court said the Constitution has to be interpreted in a manner that's fully responsive to those realities, and that includes the criminal law power, that it should be able to keep pace with existing values. And I think even more importantly, the court found that this wasn't just true for harm to humans, but also to the environment, and noted that humanity's interest in the environment extends beyond our own life and health, but also to the health of ecosystems. But it wasn't, the court didn't go so far as to give federal government complete control over substances. They need to be toxic. There needs to be harm. And that's kind of what we've now seen with the single-use plastics ban, is the court said, no, you've gone too far now. Take a step back. You can't go that far. But yes, you can regulate things that are proven to be toxic. And so that's how the Canadian Environmental Protection Act works, is there needs to be a robust assessment of toxicity before the government can regulate it. This is a big piece of legislation. It's like our primary law for doing a lot of things: pollution prevention, preventing hazardous waste, disposal at sea, greenhouse gas emissions, and environmental emergencies. It replaced a bunch of other statutes, and it's quite critical for our federal environmental protection regime. And it's primarily regulated by Environment and Climate Change Canada, along with Health Canada, where impacts to human health are at issue. To give you some examples of substances that are already regulated under SEPA, some flame retardants have been prohibited under SEPA. Certain PFAs or forever chemicals are listed, and mercury is another one. And I'll say for those first two, this might also be a good example of how controversial this scheme can be. Many people say they haven't gotten far enough in banning all forever chemicals, banning all of these dangerous flame retardants, but they have taken steps to regulate and mitigate the risks of some of those. Mercury is another good example of something that's not fully prohibited. It's the government recognizes that it needs to be used in certain circumstances, and so they've created a process for mitigation and for ensuring it's only used in certain situations. Asbestos is fully prohibited, but it took way too long. It wasn't until 2018 that it was fully prohibited. And I think one last example that's kind of illustrative of maybe when things go right is with PCBs, which was a chemical used by electrical companies and electrical equipment that was very hazardous to aquatic ecosystems. That was the subject of the Hydro-Quebec decision, was the company said, you can't stop us from releasing PCBs, and the court said, no, they can. That ban was so effective that we don't actually regulate it under anymore because companies don't use it anymore. That's not just because of Canada, that's a global effort. but it proves that we can not just regulate things, but actually move past that and get rid of them entirely and resolve the problem. One last point I would make is that it really helps when there's broad public support to ban a substance. Microbeads, those plastic microbeads in cosmetics that were around a few years ago, they're a really good example because the federal government wanted to ban them. The public didn't want them in our waterways, but so did industry. Industry didn't want to compete with other jurisdictions that were allowed to use microbeads. And so there was this broad support to prohibit microbeads under SEPA, and that was successful. So once a substance is listed as toxic, then SEPA allows for regulation and prohibition of substances. Toxicity is defined as a substance that may enter the environment in a quantity or concentration that has a long-term harmful effect on the environment or on biological diversity, a substance that may be a danger to the environment on which life depends, or which may be a danger to life or human health. And like I said, this needs to be done through an assessment that can take some time and be extended over long periods. And that's kind of the problem with SEPA is getting that moving as quickly as possible. This is an oversimplification of how the process works, but essentially there's a domestic substance list under SEPA, which is all substances manufactured at a certain level in Canada. And then kind of whenever environment and climate change feel like it, they're allowed to take a look and decide whether something needs to be regulated. So there's something called a screening assessment that can be triggered by a number of things, decisions in other countries, new science, industry information, that would then force the government to take another look. Part of the problem is that Environment and Climate Change Canada are under-resourced and lack capacity. Even if they're interested in getting something regulated, they don't always have time to do so and the ability to do so. Political will is another barrier. But the idea would be to regularly be making sure that there's not toxic substances left unregulated. When something does raise those red flags, they're meant to go onto a priority plan, which is basically the queue of what's up next to be assessed and potentially listed. And what we're trying to do with our request, excuse me, is get 6-PPD added directly to the priority plan. So put it to the top of the queue, kickstart the process, and get an assessment done, and then get it regulated as quickly as is possible. Our provision, our request is under Section 76 of SEPA. And this is not a new provision to the Act, but it is an amended one. Basically, there used to be a process where you could make requests under SEPA, but the minister didn't have to do anything. You could say, thank you for your letter. We're doing a couple things on that chemical, and that's the end of it. Ecojustice, back in only a year ago, we were fighting for this provision to be strengthened and make it something with a little bit more teeth. It has been changed. Now the minister must make a decision about whether to prioritize something for assessment or not. The minister needs to respond within 90 days, and reasons must be provided about whether they decide to grant the request or deny the request. And those reasons must include certain considerations, whether assessment would protect the environment, human health, and the health of vulnerable populations, must consider the precautionary principle and use a weight of evidence approach, and consider cumulative effects from, in this case, not just 6-PPD, but all other contaminants affecting vulnerable species, be they coho or other salmonids that are affected in any way by 6-PPD. I'll note that 6-PPD was very summarily assessed by, under the Canadian Environmental Protection Act back in 2018. This was before all of the new evidence has come out and the Tien paper and everything that you've been hearing about today. So it's not the fact that Environment and Climate Change Canada completely dropped the ball in not reviewing it back in 2018, but we do think now that the fact that all of this evidence has come out, it's time to actually assess it and list it based on the clear evidence of toxicity. So in our request, we summarized the latest evidence, a lot of which we've heard today. We referenced all the sampling work that's been done. We, in conversations with the BC Conservation Foundation and some of the work that's been coming out of Metro Vancouver, all the sampling results that have been done, the likely exposures, as well as all this emerging evidence of toxicity. It's our submission that while evidence just on the impacts to coho should be sufficient enough to list 6-PPD as toxic, if there's any uncertainty about how widespread and bad the impacts are, it should still be err on the side of caution and the precautionary principle, and list 6-PPD as toxic. And we also made submissions, as I said, about cumulative effects from all the other contaminants and road runoff, and also these issues of exacerbated effects from climate change. So these longer dry spells and bigger flood events, meaning that larger volumes of 6-PPD are being deposited all at once. I think also the issue of electric vehicles being more widespread. These are heavier vehicles. The tires run out quicker and deposit 6-PPD at a higher rate. I also pointed out earlier that fisheries are an area of clear federal jurisdiction. There's no question that's the federal government's responsibility. And what we have here is very serious, concerning impacts to fish and fish habitat. The Federal Fisheries Act prohibits any activities that harm fish or destroy fish habitat. It also prohibits the deposit of what's called deleterious substances, so any substance that degrades water in a manner that harms fish. And so all of these are true here, where we're seeing these mass deaths and toxic substances being deposited into water. In terms of what we expect to see happen next, we submitted our request in early February, and a decision is required within 90 days. So that means we'll get a decision next week, May 6th, about whether the federal government is going to prioritize assessment of this and take these concerns seriously. We expect our request to be granted. This is a case where we have overwhelming evidence that's been generated over the past few years, evidence of toxicity and evidence of exposure, and just like how widespread 6-PPD is across Canada. Canada's starting to fall behind other jurisdictions, where we're seeing the United States take action, where we're seeing Europe even start to take a broader look at non-tailpipe exhaust emissions. And again, we say any uncertainty about just how big the problem is not an excuse. It's time to at least start looking at this. Doesn't mean prohibit right away, but it means start regulating, do an assessment, and take steps to address this problem, because this thing can get drawn out for years otherwise. If our request is granted, there's no strict timeline to go from granting the request to assessing the substance. They're talking about putting out those timelines, but that hasn't happened yet. There is a strict timeline once it's assessed and listed as toxic. So it's 2 years to propose a draft regulation, and then 18 months to actually publish that. But to get from granting our request, if it's granted, and regulating it, there's still that open time that could take longer if there isn't pressure from the public, if there isn't continued advocacy about the importance of this issue. And so that's our plan, is to continue advocating on this project and stressing the need for urgent action, because as I point out on the slide, the tires that are currently being manufactured and used are going to remain in use for years. So there's a delay from actually prohibiting the substance and seeing the result on the land and waters. So there's a real urgent need to start addressing this immediately. Finally, just to wrap up, maybe to step back and think about the bigger picture once again, even if our request is granted, there is this need for Canada to take a broader look at tire wear, at brake wear. For a long time, tailpipe exhaust has been the focus of regulations. And we think that regulating 6-PPD is a great first step into putting more scrutiny on the tire sector and brake sector, which have really escaped scrutiny for decades. Europe is doing a much better job, or at least starting to, by setting limits for emissions from these sources. And there's also ongoing research already happening, thinking of one project in particular from the University of Toronto that's comparing tailpipe emissions and non-tailpipe emissions and gathering more data sources for the Canadian context. So moving on from this, we would like to see that broader action taken by the Canadian government in line with jurisdictions like Europe. And really, it's going to require a global effort to start scrutinizing the sector and making change. So that's all I had.